Okay, welcome everyone. This is a monthly webinar we put on from the Quattrone Center as part of our training and technical assistance provision under the Upholding Rule of Law and Preventing Wrongful Convictions Grant funded through the Department of Justice, the Office of Justice Programs. My name is Marissa Bluestein. I'm an assistant director at the Quattrone Center, which is at the University of Pennsylvania Carey Law School. And I am very quickly going to hand over pardon me, to the extraordinary Anjali Ranadiv, who works with us part-time as an expert in DNA matters. Anjali worked for the National Institutes of Justice and in helping to refine DNA policies and has her own consulting business. And she has worked in numerous wrongful conviction cases around the country on analyzing DNA, thinking through DNA testing plans, looking at the results, what do they mean, and how to interpret them, and is available to grantees to work through the DNA grant as well. But we're just so thrilled to have her with us. And she's a little under the weather. I'll give that to you up front. So let's show her some grace. But Anjali, thanks so much. And I'm handing over to you.
All right, thank you. I'm assuming we have people from all over the country, so good morning, good afternoon, depending on where you are. And I'm here in Arizona where we don't observe daylight savings, so I don't even know what time it is anymore. But as Marissa said, I'm just recovering from some minor sinus surgery, so I sound worse than I am. But my role with the Quattrone Center is the DNA expert liaison for the post-conviction grant through BJA. And my background is in forensic DNA as an analyst. I am also an attorney. And so I work as a consultant for the last 20 years. I work with individual cases, current cases that are having testing done for the first litigation, as well as with conviction integrity units and innocence project organizations all over the country, examining cases that are trying to move forward with appeals. So I'm just going to moderate today. I'm going to also turn it over to this amazing trial team from the Washington Innocence Project. We have three people that are going to, I think only two of them are really going to present, but we've got Laura, Sarah Beth, and John that are going to kind of speak to different components of the effort that the Quattrone Center assisted with in a case that had you would think at first were almost like the perfect storm of facts. And any of us that work in this space might think, this would be like the poster child case for success. And yet it doesn't always work out that way. So they're going to talk to you about the facts of the case, what we did, what they did, the small role that we played in helping, what the outcome was of our collective efforts, and then kind of where that leaves them related to this case, but also we hope to be able to provide you with some lessons learned from this effort. And if there's time, perhaps get even, feedback from all of you on maybe if you've done anything similar, or if this spurs you to think of, some different ways you can address some of these issues in cases that you might have in your, on your agenda right now, or that might come down the pike. So I'm not certain who's starting. Is it Sarah Beth or Laura who's going to take us? All right. So I'm going to turn it over to Sarah Beth Johnson. She's going to introduce herself and take over the slide deck. And I am here to help answer questions and just kind of keep you all herd cats.
Oh, great. So I'm Sarah Beth Johnson. I work at Washington Innocence Project as a staff attorney. I'm here with our executive director, Laura Zarowski. She's actually going to get us started and talk a little bit about this case. And then I'm going to go into some of the work that we did. And we have a best practices document we developed for working with experts that we're going to share, and hopefully make this process easier if others want to replicate it. And I should be able to share my screen now. Is that showing up?
Not yet.
And just while we're getting that set up, Marissa said in the chat, if you have any questions, please put them in the chat. When I get to that part, which will be in just a moment, there's a lot of facts to this case that I'll be leaving out. So if there are any questions that you have as they come up, then please put them in there so we can clarify that. And I think Anjali or Marissa will be monitoring that. So, oh, great. Thank you
Yep,
so much.
absolutely.
Great. And I can just jump into and make my introduction. My name is Lara Zarowski, as Sarah Beth said. I'm the Executive and Policy Director for the Washington Innocence Project. We started as, we were the first Innocence Project after the one in New York. We were Innocence Project Northwest, founded in 1997. And I've been with the organization, who I was as a student, and then joined as our first policy staff attorney in 2010 after working in the state legislature, and have been our executive and policy director since we became an independent nonprofit in 2019. So having said that, I've been here for coming on 15 years now. I'm in my 15th year, and I am so happy and grateful that we have the opportunity and the platform to talk about this case, because I think one of the most frustrating things about having a case like this with facts like this and having the outcome that we did is that we feel really powerless. And so it's good to have an opportunity to put the information out there and see what can be done, share our ideas about how to respond, and would really welcome thoughts and input from anyone out there. It's fair to say that this is the kind of conversation that I would have said had come and gone by this point in our knowledge of DNA and exoneration cases and that sort of thing. We're going to be doing today, what we're going to do is explore the idea that opposition to exonerating post-conviction DNA results, sort of why clearly exonerating results are sometimes not accepted as such, what that opposition looks like, and how can we respond. And we're going to talk to you about all of these things in the context of the case of our client, Cody Klepper, in Washington State, and sort of how that all played out to demonstrate some of these things and illustrate them as we go along. So I'm going to provide you, as I said, a very brief summary of the facts in this case, because they are complicated, needless to say. And then I'll be turning it over to Sarah Beth, where she'll discuss our litigation response and our amicus strategy and how Quattrone really stepped in to help us with that. So Cody Klepper, I do use his full name because we have filed many things in the court. So this is public. So just for, we kind of went back and forth about this, but all these records would encourage you to look through the records in these cases if you're interested in seeing how the opinions came through. He was convicted in 2011 of a rape and burglary that happened at the end of 2009. What's interesting about this case is, well, a lot of things, but the evidence against Cody in this sexual assault was an eyewitness identification that is sort of widely agreed to be, well, except for the prosecutors, to be an unreliable eyewitness identification for reasons that I'll explain, and circumstantial evidence that placed him at the scene, which was an apartment building where he was a maintenance person. So he had access to the apartments in that complex. Cody wrote to us a number of years after he was convicted and asked for post-conviction DNA testing. I will say that the eyewitness identification in this case was really is an important factor in terms of the DNA and how that sort of played out later. Cody was known to the victim in this case. She lived at the apartment building. He was a maintenance person. They had a good rapport and a good relationship. When she reported the crime, she said she didn't know her attacker and just said that he was may have been or looked like or could have been one of the maintenance people. So it looked like one of the maintenance people. That description was taken to mean, that it was, or maybe that was the easiest route. A lot of different possibilities were not explored in terms of what she could have meant by that. But she did describe them that way, but also said she did not know her attacker. She didn't know who it was. She was taken to the hospital. She had very severe head injuries and lost consciousness at some point before or just after making the 911 call. And she was in 2 separate hospitals where we don't see that there was any evidence that a sexual assault examination kit was taken. However, while she was in those hospitals, she was given 2 identification procedures. Both of them were sequential photo lineups while she was at the hospital. In both of them, Cody's picture was there, and both times she said, "No, I know who that is. That's Cody. It wasn't him," and moved on. And she made a very strong identification of someone else that was in the lineup. During the course of the that person was arrested and charged. And in the course of the investigation, a rubber scrap that was believed to have been the tip of a rubber glove that was at the scene was tested for post-conviction DNA testing. It showed that there was evidence of 2 male profiles, and I'm not going to get into the details of this. I'll let Sarah Beth get into that, or maybe Anjali. But suffice it to say, there was indication that one of those profiles was consistent. Oh, thank you for that. There's the slide. One of those profiles was consistent with Cody Klepper, but he and 400 others in the male population. The other one was a fuller profile, but an unidentified person. Based on that, law enforcement told the victim in this case that Cody Klepper's DNA matched the evidence at the crime scene. And that's a really important piece of information for moving forward in terms of what subsequently happened. The victim in this case was a chemist by trade. She was certainly scientifically minded, had an understanding of science. And so being told by law enforcement that there was a match to that evidence was certainly compelling, and maybe even more so for someone in that circumstance that had the background that she did. They dropped the case against the person that she had very strongly identified in the lineup and charged Cody Klepper. That was the only DNA testing that was done. There were other items that were collected during the investigation, including the sweatband of clothing that the victim was wearing at the time of the attack. And I said that this was a single perpetrator sexual assault. It was a home invasion. She was by herself. She had not had sexual contact with anyone else anytime recently. She lived alone. And so all of those things are important in, the subsequent testing that we sought. And right now what we're talking about, just to take a little bit of a step back, what we're talking about here is opposition to exonerating DNA results. But I do think it's important to note that at least in Washington state, we sort of have a growing resistance to even getting DNA testing in the first place. And there's been a bit of a bell curve, but we're on the other side of it. We really have to fight for post-conviction DNA testing in most of our cases because prosecution is just simply not agreeing, no matter how probative we believe that might be. And that's the why I can't answer. I wish I could, but that is definitely something that we're seeing increasingly. In this case, though, the prosecutor did agree to testing. We did not have to litigate it. We put together a motion for post-conviction DNA testing when we were, law students worked on it, had conversations with the prosecutor, and they agreed to testing. So the evidence was sent out. And as you can see here, there were a number of stains that were on the victim's clothing. And what they rendered was very clear. A mixed profile with at least one male contributor. Cody Klepper was excluded. Unknown profile number 1 was redundantly seen across multiple stains on the victim's clothing. This is where we would say this is the gold standard for what you're looking for in a DNA case. This is what we had always said. Here's what you want: a single perpetrator sexual assault, no evidence of any other sexual activity or anyone else's DNA having any reason to be there, and redundancy. So that that excludes the person that you're representing. These are sort of the facts that I think we all look for. And we used to call that the gold standard. And then we started calling the platinum standard, which we had never actually seen before, a circumstance just like that also had a CODIS hit on top of that. And that was a circumstance that we found ourselves in when these DNA test results came back in 2021 and revealed not only that none of Cody Klepper's DNA was was on the clothing that was tested. He was excluded as a possible contributor, but also it was it included a person that was in CODIS. So as you might imagine, when we're in that situation, there's a set of expectations when we're doing this kind of work about what is then going to happen. As I said, we had never had circumstances where we have such clear evidence. We had DNA exonerations previously. And that the opposition just to testing in the first place is pretty deep rooted. our post-conviction DNA testing statute was passed in 2000, and we essentially had nothing but opposition from prosecutors in terms of moving forward with testing. So in 2005, had to have the statute changed to put the authority into the court's hands so that they could make the decision. And only then did we have we had 3 DNA exonerations, our first 3 in the state in 2010 of that year. And so there was certainly some precedent for DNA exonerations, and none of them, they were all strong, but none of them as strong as this in terms of the facts and what you might expect to see. There were a couple of interesting aspects to the post-conviction examination of this from the prosecutor's side that I think are really important for our discussion here. First, that the same prosecutors and law enforcement officers that were involved in the initial investigation reviewed their own work. So they were the same individuals that were at the original prosecution in 2011, 2010, 2011, were the same people who reviewed this work later. I was one of the attorneys that was working on this case back in 2021 when these results first came through, and I was reviewing the communications between us and the prosecutors, and it was really like, okay, so when are we going to the prison to open the doors? This is what we would expect, this incredibly compelling evidence. And their response was, well, hang on. And what happened next was that the prosecutors reached out to the lab where the testing had been done, and wanted to speak with one of the prosecutors, or I'm sorry, one of the analysts, to understand what this could have meant and ask very specifically if this could have been transferred, if DNA could have been transferred. The scientists, understandably, for reasons that we all understand, but I think we'll get into a little bit more, objectivity, not looking like an advocate in any particular case, is incredibly important for our scientific community. And what that scientist was willing to say was that DNA transfer is a thing, and he could not say one way or the other how the evidence in this case arrived on the clothing. The state's theory was that there was sexual contact of some kind earlier in that evening between our client Cody and who was a person who was unknown to him earlier that night. They had met through a Craigslist advertisement earlier in the same evening. Sometime around midnight, there was testimony at his trial about what the nature of that experience was. And in any circumstance, even that trial testimony made clear that the other person's DNA should not have been a factor at all. And yet, when the results came back, the person that Cody, our client, had met earlier in that evening was the person whose DNA was found to have likely been the contributor at the crime scene. And so we believe, I think it's clear that there was something, it seems like the platinum standard, I'll put it that way. It seems like the platinum standard to have a CODIS hit in a single perpetrator sexual assault case. And yet in this case, because those facts were so unusual, because it was so surprising, because there was no known connection between this person who he had met earlier that evening with the victim in this case, we were in a situation where we essentially had to explain away the CODIS hit. We had to provide some sort of explanation for how it was that that person's DNA was at the crime scene if it hadn't been transferred by our client. And I'm going to let Sarah Beth get into more of the details about the likelihood or the possibility of transfer and how that was handled in our arguments. But suffice it to say, that was not something we thought was a realistic possibility based on the evidence results. It seemed like an incredible long shot and sort of a Hail Mary to be making that argument. And it was challenging to have, although we don't need a scientist to be an advocate, to kind of treat that as an equal proposition, that transfer is a thing and this could have been transfer, but we can't say that it was transfer. And so that kind of put us on a very particular route in terms of how the prosecutors were thinking about this case.
Laura, if I can interject, are you saying that they were asking you to prove the negative?
Not ostensibly, but through the court's decisions, it made it very clear that they grappled with how that the overwhelming evidence against our client, which was the circumstantial evidence and the eventual DNA or eyewitness identification that was very poor. So not explicitly, but we struggle otherwise to explain. Our standard in this case was to establish that this newly discovered evidence, which was the CODIS hit to someone else from the crime scene evidence, it was on us to establish that had that information been known at the time of the trial, the outcome would have been different. The trial court disagreed and said that information, because of the overwhelming evidence against Cody Klepper, which I've just described, that would not have changed the result of the trial.
Laura, I'm sorry to interrupt you. We have a question from the chat, which I can only answer partially. So I'm going to throw it to you. We were asked what was the initial DNA testing, and I explained that he was included on the rubber fragment with a very small statistic. But follow-up question was that a mixture, or was it only Cody's DNA on that rubber?
It was a mixture. There was another male profile, and it ultimately was consistent with the CODIS hit. So the same person who contributed, the same source of the DNA that was on the victim's clothing from our subsequent testing matched to that other profile. This is a
clarify. Sorry,
yes.
Just to clarify, that initial testing was just YSTR testing.
Yes.
They did not do PCR testing. So essentially they found that Cody Klepper's DNA and paternal relatives would be in line with that. That was the same when they eventually got this CODIS match with unknown number 1.
Exactly. Thank you for that. And I think so. I think the standard is really important. And Marissa, to your question, I think that is what demonstrates if we did not need to exonerate him at this level. That's not what the standard was. We didn't need to show that it wasn't Cody Klepper. We didn't need to solve the crime. All we needed to do was to demonstrate that this evidence, with the strength of this evidence, that had it been known at the time of the trial, it would have changed the result, and therefore he would have been granted a new trial. We lost at the trial court level, and we were sure we would win on appeal. We lost on appeal. So that's where, just a little preview to what Sarah Beth is going to be talking about. That's where we were here. There are a lot of really interesting dynamics and facts about the person whose hit was in CODIS in this case. But I think coming back to our central question, why was there so much opposition in this case? I think, of course, the one that we all opposition to accepting that this was a wrongful conviction, and that the person whose DNA was all over the scene was probably the one who committed the crime. There are a few, certainly confirmation bias. We're talking about, as I said, the same individuals who prosecuted and investigated this case were reviewing their own work. So of course, confirmation bias. However, in this case, it probably goes a lot further. This is a very small town. The elected prosecutor was about to leave office. He wasn't running for re-election. He had made a public promise that he was going to make sure that this conviction stays, that he was going to protect the victim. The victim in this case passed away after DNA results came back exonerating Cody, but before any kind of court proceedings were able to go forward. And it seemed clear that there was an emotional aspect to that the prosecutor was committed to sticking with that story, sort of no matter what. And I should say, in those DNA, that I don't know if I've said this, other than that scrap with the 1 to 400 statistic with the YSTR testing, Cody's DNA was not at the crime scene. And when the victim was presented with the information that his DNA was a match at the crime scene, she actually said, it's a recorded interview. She said, I cannot fathom that it was him. And then tried to find all these different ways to explain, he was in my apartment doing work a few months ago. Maybe it was this and that. And so it took her a number of many weeks after she was told that information to actually say, okay, I remember now, it was him. And that was the nature of the eyewitness identification in this case. So those are all
also was not, that sample was not semen, correct?
Right. That's right.
It was just DNA. All the other samples on the clothing were in fact presumptively tested for semen.
Semen and seminal fluid. Exactly. And the person who was the CODIS hit in this case testified at the trial because he did meet with Cody earlier that evening. He admitted to that, but he said that he came over, he found him unattractive. They had a quick interaction. There was no sexual contact and he left. He later said during interviews that if there had been sexual contact, he would have remembered. There's essentially 3 different forms of testimony. This person never gave consistent testimony and never said anything that would actually support the DNA evidence in this case. And so those were all factors that led us to just say, what is going on here? Why is there something else that's going on? Of course, confirmation bias, but this felt like it went further. We are seeing general opposition to conceding anything in our cases, and we have to acknowledge, sometimes we do. There have recent cases where we've actually had a prosecutor acknowledge were entitled to a new trial, but by and large, there is a big effort to make sure that they are able to secure some and maintain some sort of conviction. So whether that's through an Alford plea or some other way, we see resistance everywhere. And those are probably rooted in financial concerns. That we've got county managers or city managers saying, we don't really want another exoneration that's going to bankrupt our county, which is, you know, one DNA exoneration did in a different part of the state. So possibly that's it. We don't like to consider that that is how a justice-based decision would be made, but we know that it happens. Political concerns, you know, this prosecutor had very deep connections with the victim's family. The victim, in this case, her mother, was a city council member. There were just very deep political ties. He was not seeking re-election, but he was concerned about his legacy. That was through a comment that he did make, so I'm not really speculating there. And then the future impact, what is this going to mean? Is there going to be question about the integrity of our office? Are people going to question all of the outcomes? You know, are we going to be able to question every case? I will say that in this case, there is an interesting aspect to the reason that Sal, the person who was a match in CODIS, the reason that his DNA was in CODIS was because he had been arrested in 2016 and his DNA taken related to a federal charge of possession with intent to deliver controlled substances. So he, I believe, received 2 days in jail, but was at a disposition that was significant enough that his DNA was given in the course of this process. So there isn't any official record of this, but it seems clear that he's likely informing in federal cases, and we can't say that for sure, but that certainly in this case may have been an additional factor that led to so much opposition to acknowledging what actually happened in this case. And at that point, I think that given that, I'm going to turn it over to Sarah Beth, and I apologize. I think that there's so many facts that we could say in this case that it's very difficult to cabinet, and I think that shows a little bit in my presentation. So I apologize if it was a little bit all over the place. I'd be happy to answer any questions, but I think a lot of those will be answered in Sarah Beth's presentation. So thank you.
Yeah, it is a very, very complex case. I think that's incredibly clear in terms of the facts. However, it was really great that we were able to work on Mr. Klepper's case. I think everyone was very optimistic going into the Court of Appeals hearing. We, Washington Innocence Project, did not do the direct appeal of the loss of the motion for a new trial. That went out to an appellate public defense firm. So we were still supportive, but in a little bit different role. And we really were all thinking this is going to be sorted out with the Court of Appeals. It's quite clear. And it wasn't. We lost at the Court of Appeals. And so we had this very big question of what's next. His appellate attorney decided he was going to petition for a review with the state Supreme Court. It's discretionary review. They don't have to accept any cases. Since we were not the counsel on that petition, we focused on some more creative and different forms of advocacy, and in particular, organizing amicus advocacy. In consultation with the Quattrone Center, we, in addition to doing amicus submission that was very legally focused under our submission name, Washington Innocence Project, we worked with them to get scientists together who were willing to sign on to a very unique amicus memorandum that was not taking a stance in terms of the legal position, but raised several concerns regarding how the science was treated in the courts. And we really were hoping to try to be creative and do something unique. And the process itself of developing it did work out very well. And I think we're all very proud of the work that came out of that. I do want to say, because I know many folks here are at CIUs, I do think that can sometimes be different in terms of if there are rules about your government agency, you can or can't submit an amicus brief based on local rules. However, hopefully, even if that's the case, the information about working with experts, we hope will be applicable no matter what stage a case is in. And our hope is by giving this introduction, it can make some of the road bumps that we ran into in this process easier for other folks. So I wanted to start about amicus advocacy generally, in case people don't know. Amicus curiae, or amici for plural, is Latin for a friend of the court. The concept is that someone who is not a party, not representing either side to the case, this friend of the court, is allowed to provide a legal submission to assist the court in making some type of decision that's in front of them. That may be whether or not to accept a case for review in a case of discretionary review, or regarding a stance or a side on a case that has already been accepted. The biggest thing that's unique about amicus advocacy is you get to have a much broader focus than one of the parties' briefs, even in a direct appeal, when you are otherwise, the court is limited to what's just on the record. You can focus on things like future implications, future impact, impact on other cases, public policy, things that normally would not be seen as typical or allowable arguments even. And one of the things I think is important to highlight is this does have an impact. I pulled from a few different sources that the 2017-2018 term, every single case involved at the United States Supreme Court, everyone that was accepted for argument had involvement with amicus advocacy. In that same term, there were 23 majority opinions, 21 dissenting opinions, and 5 concurring opinions that had direct cites to amicus briefs that were filed in the case. So the opinions directly cited to the amicus advocacy. Of course, we're not all going for this, it's US Supreme Court, but I do think that shows this is having an impact, and justices at the highest level are actually not just reading these, but relying upon them for support for their rulings. So in this case, we really wanted to intentionally be creative and unique. The reason being is, first of all, it clearly seemed like our prior approaches were not working. This was a situation where, unfortunately, we really expected something else to come out of the Court of Appeals ruling. It did not. And so we were thinking that maybe the justices aren't hearing it from us. They need to hear from experts. And if they hear it from them, maybe that'll be more compelling, that they would be more inclined to believe actual scientists giving neutral explanations of how the lower courts got the science wrong. The other big thing that our hope was is this would simplify the science. There was an expert report and declarations, there were DNA reports, there were studies, all on the record in the lower courts. But our hope was maybe we need to just break this down to its simplest parts, and that will come across clearer. We also came into it identifying the things that we believed were wrong, and that had been gotten wrong. One of the biggest ones was the YSTR testing and reliance on that it was an affirmative match to Cody Klepper's DNA, misstating really what YSTR testing can tell, as well as not really factoring in the count that this other individual had the same genes that showed up in that YSTR testing. His DNA profile was also consistent, and really a disregard of that. Another thing that we were very much wanting to push back on was the idea of the transfer theory being equally and more likely. And when I say the transfer theory, to be specific, what happened at trial was this other witness indicated Mr. Klepper came to his house after he posted a Craigslist ad. He decided he did not actually want to have any type of sexual encounter with him. They shared coffee. It was a 15 to 20 minute interaction, and then he sent Mr. Klepper home. Cody Klepper testified that he got there, they talked, that this other individual performed oral sex on him. Mr. Klepper was in a relationship with a woman at the time. He felt very, very guilty and ashamed, so he did not reciprocate, told this individual, please don't contact me again, and left. So they had very different testimony at trial. The prosecutor brought this other witness in at the motion for a new trial and had them testify, and the testimony was quite different. At the motion for a new trial, this witness testified that actually the encounter was more like an hour to an hour and a half, that there was a lot of physical contact to include touching, hugging, and rubbing their bodies against each other, and that this other witness indicated he may have or possibly ejaculated, but he could not say for sure. That provided the basis for the state's theory that the genetic material from this other individual transferred onto either Cody Klepper's skin or hands, that Cody Klepper then drove to the apartment complex, bringing this genetic material with him, committed this rape and burglary, transferred this other individual's semen onto the victim's clothing, did not transfer any of his own genetic material, and that was the reason for why this alternate suspect DNA was all over the crime scene and not Cody Klepper's. And so a lot of what we were contesting were things like what would be able to be realistically transported in that manner and still preserved, the likelihood that transfer in that way could occur without Cody Klepper's own genetic material being transferred. There were a lot of things that we really were pushing back in terms of affirmative statements the court made about the DNA results in the science that we just did not agree was correct. It was also, the Court of Appeals really tried to minimize the impact of the DNA by saying, well, maybe it was just a little bit of sperm that transferred and then it soaked through the clothes when they were bagged up for evidence, things like that. And so there are a lot of statements that we were really wanting to address through this forensic science memorandum. Our goal was to really emphasize history and experience that the participants, the signatories, had. Oftentimes, these are scientists with experience working in local or federal crime labs, state and federal crime labs. They had experience doing exactly this type of DNA testing. They had experience that also was not just for working as a hired witness or working for defense. It gave a lot of neutrality. We also wanted to signal that we had a critical mass of experts to show this was such a significant miscalculation by the lower courts, that there are just so many things that these scientists were saying. The evidence simply does not match the legal or factual conclusions that were in this court opinion. These are our concerns. And we really wanted to focus on a neutral stance to help us carry weight. And that's for a few reasons. Number one, many of the experts were not willing to sign on to any advocacy-based brief where we were saying Cody Klepper is innocent or saying he should have been found not guilty, anything like that. They really were only comfortable if it was just about the science. And that's very important for them, to be neutral, to protect themselves, to protect further work that they're going to do in other cases, shield themselves from accusations of bias and cross-examination. So that was important. But also, as Lara touched on, the Court of Appeals opinion really focused on the idea that this other individual, they didn't see how he had any motive, and they didn't see any of the circumstantial evidence that they thought was more compelling with this, with the defendant, Mr. Klepper. There was a lot of focus on, well, the DNA can't explain how he found out about the apartment complex. How could he have gotten there? How would he have known to go there? And so we wanted something that would really steer the courts to focus on the legal standard and the DNA results, rather than these questions of, well, why haven't you proven that this other guy did it? It doesn't make sense to us because we don't see he has any motive to commit this crime, things of that nature. We really did feel like the lower courts were looking for us to prove this alternate suspect's guilt rather than looking at the DNA and its impact it would have had on the original trial. Finally, and perhaps I think one of the more important ones, is we really wanted to frame the facts, because a lot of what the prosecution had argued and stated were things that we simply disagreed with. And these experts also disagreed with in terms of what the DNA results actually meant and how they could be interpreted. We also really wanted to emphasize things that we felt were not being addressed at all by the Court of Appeals. The main one being that this witness's testimony at trial was very clearly he had no sexual contact with Cody Klepper. How could we find this transfer theory so plausible it wouldn't change a juror's mind when the jury heard from that witness he never even touched Cody, let alone would have been in a situation where his semen would have spread onto Cody. And so there were a lot of reasons why we really wanted to frame the facts for ourselves and frame the science based on how we saw the science for the court. And when we got through this process, one of the things that I think was helpful is Laura found an attorney who really focused on forensic science and the law, who is willing to file this amicus brief on these scientists' behalf in Washington State. While amici can be from anyone, it has to be, the actual submission has to be filed by a barred attorney in Washington. It's important for organizing this because we thought it was a powerful tool to help Mr. Klepper's case. Ultimately, we really wanted to focus on this neutrality. So bringing someone in who A, had a focus on DNA science, and B, while was an attorney, was not involved in the motion for a new trial, we thought that helped our stance of showing we're really trying to be neutral here and just show there are serious problems with how the science and the DNA was treated in this case. I want to pivot because that's a frame for how we approached this case and got into it with Mr. Klepper, but just talking about working with experts in general, because what we found was this was a really helpful process for us because we learned a lot of lessons on what we could have done to make this process easier. And the biggest thing for me, and for a little bit of my history, I was a public defender for 7 years before going to Washington Innocence Project. So I had experience crossing experts, had experience directing experts, working with experts, but all at the trial level. And I quickly found that that experience that I had as a public defender was very different than working at appellate level amicus advocacy. In one major part, because we were trying to make this as neutral as possible. It wasn't really advocacy so much as raising concern about science without taking a stance on the actual ultimate case question. So we really took time to talk with everyone involved and get a sense of what were the best practices and how could this have been improved, and how can this be adopted to other cases? Because ultimately, one of the things that we think is it could be perhaps a very compelling thing for courts to start seeing over and over again briefs from forensic scientists with this type of experience pushing back against blatant misstatements of science and DNA by prosecutors or even by lower courts who are opposing some type of relief. We think that that shows a very strong pushback to some of this resistance that is coming from basically the most fundamental source it can, people who focus on this type of science. So the first step that we came up with is essentially preparing. And the biggest thing that I think we learned is we needed to prepare more before we even got to the point of talking with an expert. And the reason being is if you have what it is you want specifically, what the boundaries of the work will be, what the expectations are, things like that set out in advance, you're not having to repeat those questions later on. And it gives the expert something to frame when they may be working on something that's different than what might be average at the trial level or what they're used to. And so the biggest thing is actually have a very coherent sense of what are you asking this expert to do? For us, it was we would like an expert that's willing to draft this amicus memorandum that says, these are things that after reviewing the materials, we have concerns that were misstated or misinterpreted about the DNA science, and have that be something that other experts would be willing to sign on to. We did find an individual who was willing to draft that with us with the help of the Quattrone Center. And a little later on, Anjali is going to talk about some of the things that the Quattrone Center can do to help find experts and help work with experts. But what we didn't do a great job of getting across is we don't need an answer to every question that could come up at trial because we're not there yet. We really need just a focus on what was in the Court of Appeals opinion and what was wrong in that, what was misinterpreted, what was misphrased. And I don't think that I gave our expert a great understanding of what that focus was until much later on in the process. And so that was something that I think I could have saved some of her time and my time by being a little bit more clear about what questions actually needed to be answered versus what would be a question later on, but didn't need to be addressed right now. The other piece of advice, and this goes, I think, for any time you're working with anyone on a case, is that you need to look into who this expert is, get recommendations, talk to other colleagues, do research, look online, talk to them, and get their insight into what could be a potential problem, what could be a potential benefit. Have they made public statements, published articles, things of that nature on the topic you're asking them to either testify about or write a report about? Are there any shortcomings that they may have in this discipline? Do they know of any shortcomings in the discipline? Are they aware of areas where there are internal conflict in the field? Are there questions that are unanswered? You want to ask that of them and get their insight in things that you might not think of or you might not know to ask by getting their insight. When you're looking for an expert and when you're looking for someone, I think it's really always a great tool to talk to other attorneys who have worked with that individual. You can also speak with other experts, get their insights. And one thing you always want to do is discuss any potential issues with impeachment. If someone is going to testify, is there anything we need to know about to prep for cross-examination? Next thing is try and maximize your efficiency and your impact while working with your experts. They can bring clarity and depth to the case, but they need your help understanding, particularly when it comes to things like legal proceedings, legal jargon, especially if it's in a stage like an appellate stage where they might not be particularly familiar with practicing. I think it was really important to give legal pleadings to the experts so they can see what the arguments were made at the lower levels, see what stances the parties made. Even if you're not asking them to discuss the legal things, they can at least get a sense of what's being argued in the case and get more context. We talked about this already, but maintaining neutrality is really important because coming across as biased, it loses credibility with the judge. They're subject to attack on cross-examination. If this is a case that's going to eventually be heard by a jury, the jury will question them. It's really important that they are advocates for their finding and analysis, not for the case, the individual, or a particular legal stance. And I was very grateful that there were times where there were things I was asking of this expert, and their response was, I'm not comfortable doing that. I feel like that's getting out of the realm of neutrality. I feel like that's too argumentative, or that's too much of taking a side. I think that really showed they were committed to being neutral, and that also I had a better understanding of what their sense of what that meant was. Your role is to tell your client's story, and you can do that while your expert focuses on the science. So you want to use your role to develop personal interest, to develop the legal arguments, to develop the personal arguments, to tell the story. And you want the expert's work to enhance that. In terms of kind of the logistical things, this was another area where we ran into a lot of unexpected road bumps. One of the things that we thought would have helped is if we had a summary document, particularly because there were a lot of different experts that we were asking to sign on and who did wind up signing on, excuse me. That way it would have had a lot more clear understanding of what was going on in the case, instead of having to repetitively say this to every individual in a conversation, things like that. It is worth noting, if this is a proceeding where there's discovery requirements, someone's going to testify, things like that, it's important to try and keep things that would solely and only fall under work product and would not be disclosable separate from most things that would be. In this case, because there is no testimony, that wasn't really an issue, but I can say from past experience as a public defender, there have been times where I've been at the office at 11 p.m. having to redact emails that I really, in retrospect, could have kept separate and not had to go through each email and see what is work product versus not. So that's something to keep in mind on your end, because that's ultimately your responsibility. So I just recommend, keeping it in separate emails, just making sure you have a sense of that if discovery is going to be something that comes up in a case later on. Keep track of what's being shared. I recommend having records prepared before you get an expert. That way, if they feel like they need more information, you already know what's been provided, what else might be out there. That'll make that process smoother. We also recommend having a point person. There are some times where there is some miscommunications that simply happened due to too many cooks in the kitchen. Having a point person can be really helpful, so you're not duplicating work. Also can be helpful so that everyone is aware of who's responsible for communication, who's responsible to keep up on these things, who to ask questions to. So that's one thing that we would recommend. And finally, talk to your expert about what you're providing. Don't just provide it to them. You don't know what questions they might have unless you guys are communicating and asking about it. In our case, there are some times where we thought this record was clear and it was not to our expert. There are some times where our expert didn't understand something, things like that, it showed us the value of checking in, not just sending these records and then assuming everything's fine. Definitely do not leave your expert in the dark. It's important for them to understand what not just your stance is, but also what the other side is saying, what the next steps are, what the framework is. Simplified language is important. Judges probably don't have a background in this. Most attorneys don't have a background in science. It's really important to make sure that this is understandable by a non-scientific audience, but especially by an audience that, unlike people in this type of practice, might not be as familiar with these issues. If you're in front of a judge who spent their entire career practicing civil litigation, DNA may be a very, very new thing for them, depending on what they're doing. If you're practicing in front of a judge who spent 5 years as a public defender and then 20 years as a prosecutor before becoming a judge, they may be very familiar, but you're not necessarily going to know that. So you want to make sure it's simplified language. And that's something that can require a lot of conversing back and forth with an expert. How can we simplify this while still keeping the essential message intact and scientifically accurate? And finally, build in extra time. Communicate deadlines, always set deadlines, even if it's a situation where it's just an artificially imposed deadline. I think it's important to have those goals set and really build in more time than you think you will need. There were so many things that delayed us that we did not expect would delay. And also just the general things that happen. People get sick with the flu. People go on vacation. There could be a natural disaster, things of that nature where you just have to think about you're going to need more time than you think you do. And if you're ready for something early, there's no harm in that. There's a lot of issue if you're filing something late. So just be very aware of deadlines and timing. And now I want to turn it to Anjali to talk about how the Quattrone Center can help, because they really were integral to this process, and particularly integral to networking with these experts and finding individuals who are willing to work on the case and get us.
Sure. So it was a very eye-opening experience from our perspective. As I said, my background is in forensic DNA as an analyst in the lab, but then also as an attorney and now as an expert. And a lot of what Sarah Beth covered maybe things that some of you might not think about. And I'm sort of a weird unicorn because I have a legal background and a scientific background, but I also teach a course here at ASU to the forensic science students on testimony and ethics. And a lot of what we teach them is that they have to be able to explain whatever their forensic discipline is that they choose to go into. It doesn't matter how fabulous they are and how smart they are and how well they know it. If they can't explain it to their attorneys and the jurors and the judges, presuming that all of those people don't share the same background, which we know that they don't, if they can't explain it in a fundamental, basic way so that it is understood, they're not doing their job. And a lot of what happened in this case, as has already been explained, I think, we don't know where the disconnect was. We don't know if the science was not adequately explained, whether it was perfectly explained and just not understood, whether all those other issues that Sarah Beth and Laura talked about, confirmation bias, political, financial, whether all, the sort of the totality of those things came to bear. But what we did at the request of WASH IP and after sort of brainstorming collectively was, we decided we've created these briefs at the lower level at the earlier stages that didn't succeed. And so I was the one that was tasked with trying to identify sort of a collective group of expertise that would agree to sign on as signatories to the brief that was written by one of our colleagues and provide what we hoped was a more powerful presentation, because it was backed not just by, not just by one attorney or one scientist, but I don't have the number in front of me, but I believe we ended up with 15 or 16 different experts, as was said, from a background of state, local, and federal agencies with a collective experience of over 500 years of forensic DNA science experience. And a lot of what Sarah Beth talked about would have been helpful. We kind of learned along the way that, I had probably 25 different conversations, because not everybody we talked to agreed to participate, but I had these individual conversations where I was recapitulating the exact same information, where if we had maybe sort of a document that outlined the facts of the case and the science that we could have provided prior to my conversations, that might have saved some time. But now hopefully, if any of you decide to go this route in the future, you'll learn from that. But we had conversations, we provided documents to those that requested them, that were willing to take the time to review the initial pleadings, the initial transcripts from earlier hearings, and then make their own decisions whether or not they would agree to sign on. There were some people who, again, these are mostly scientists that have worked in the legal arena as experts, but are not lawyers. And so, as Sarah Beth said, maybe had a lot of experience testifying in instant cases, or even maybe in post-conviction, but not ever in this capacity. So some of them could not get past the idea that even though we had this CODIS hit to someone who was not the client, they couldn't get past the fact that they weren't certain that Cody still wasn't involved, and they were uncomfortable signing on. And we explained many times that the legal standard, the question that we were looking at right now, was not was he guilty or innocent? Like Sarah Beth said, we're not there yet. We're just trying to get over the hurdle of, is the legal standard for a new trial met? Does this CODIS hit qualify enough as new evidence that should at least give him a new trial, where now, if a new trial had been granted, the jury would hear the same evidence they heard at the initial trial, but it would be balanced by this additional evidence that was not available earlier. And enough of them understood that assignment and understood that, we weren't at the point where we were determining actual innocence or guilt or innocence. We were just trying to, sort of climb this hurdle. And that's kind of what we, as at the Quattrone Center, that's what we were able to offer. We got the brief written, which restated a lot of what was originally given to the appellate court, but we fleshed it out a little bit more. We were able to add a little bit more information. And then we had what we thought was a very powerful presentation by, this group of scientists. Within the forensic community, we understood that some of the names that we had on this document were very powerful. We understood that the court didn't know who most of those people were, and it might not have had the same weight that we hoped that it did. But that was what we tried to do. That was different than what maybe is done routinely. And because it wasn't the favorable outcome that we had hoped, we are now, and the Laura and John and Sarah Beth are kind of at a place where they have to figure out what they're going to do next. But we wanted to present this to everyone in case it's something that maybe is something that you would consider. And in addition to what we did in that case, thank you, sorry, Beth, for bringing this slide up. I just wanted to, offer to all of you some other things that, if you have cases with evidence, these are some of the things that the Quattrone Center is able to offer you under our grant. So we do have, myself on board as the DNA expert liaison, but we also have access to other experts where we can help identify whether there's evidence available. If you do have evidence, we can go through and, help you identify what type of testing, whether it's, conventional testing, YSTR testing, mitochondrial testing, even, genetic genealogy. There's all these other types of platforms depending on the facts of the case, how long ago the conviction was, and what questions you're trying to answer, that we can help you go through all of that, create a testing plan, help look at prior results, help identify, what additional testing might answer questions that are open, help you identify private labs, because, as you've heard in this particular case, having the same lab that did the initial testing do additional testing and review earlier results certainly could be considered a conflict of interest in some jurisdictions, in most jurisdictions. So having further testing done by a private, independent, neutral lab, if that's an option for you, we can help you find laboratories that have the capabilities to do the types of testing that might be appropriate for your case. And then, we're also available to help you review the results of any testing that might be done and, go further with answering questions, or, even just consulting on what next steps might be appropriate to help you move your case, ahead if possible. So as Sarah Beth said, they did not get the result they were hoping for, but, we hope that this, everything that we went through and the lessons that we learned might provide some of you with additional options that maybe you hadn't considered in the past. And if we can start to make these amicus briefs part of a routine post-conviction plan, maybe at some point, maybe it'll be the next one, maybe it'll be the 5th one, maybe it'll be the 10th one, but maybe at some point the courts will start to realize that, we're not going away and we're not going to just lay down because the science was not accurately interpreted. And we're going to keep pushing back with neutral interpretation of the science where it wasn't correctly interpreted, in our opinions. And, hopefully maybe one of your cases will be that breakthrough case where we'll be able to do another one of these presentations 6 months from now or a year from now with a different result. So I don't know, Marissa, I don't know how much time we have left, but yeah, do we have questions from anybody?
So, yep, we still have a few minutes left for folks who have questions for Anjali, for Laura, for Sarah Beth. Please put them in
Mr. Johnson, I see your question. Yeah, most of the, I think all of the signatories that we ended up with were forensic DNA analysts. We had 1 or 2 attorneys who worked in the post-conviction space. We didn't have anyone who was a statistician per se, but we certainly have, my husband is a forensic statistician. We have access to them. If if anybody has a case where you need someone to look at statistics and, like we had that 1 in 400 statistic, which, was wrongfully talked about at the trial level as this is a match. Nobody in forensic DNA is going to call a 1 in 400 YSTR stat, especially a mixture, a match. It might have been an investigative lead, but it was certainly not, it was overstated and misinterpreted and misrepresented. And we hoped that we were able to clarify that. We thought we were able to clarify and minimize the importance of that match or that statistic, but again, didn't have the favorable outcome we hoped for this time.
And I'm going to go ahead and launch the evaluation poll. I actually encourage everybody to fill those out because those are necessary for BJA for being able to report back on the
how helpful these kinds of webinars are. But the question I have, and I'm not sure if this is a lawyer question or an Angela question, but I guess I have some concerns about giving the experts the filings, and because I have a concern about confirmation bias issues. How did you address that? Why, how did that come up? How did you talk about it? And why did you make the decision that you did to provide all of the materials as you decided to?
Well, in this case, it was pretty simple because some of the people involved, some of the scientists involved were asking to review the materials. And since they wanted to, we thought it was fine. I think really that's going to be on a case by case call. In this case, I think in some ways it was very helpful for them to see what the arguments were, because that kind of helped frame the discussion of how are we going to address these things that we think are being misstated or incorrectly interpreted. But I do agree that can be an issue in a case. I think it's also something to keep in mind in terms of, your own jurisdiction's practices. If that's something that comes up a lot in cross-examination, maybe you don't want to do that. But for us, I think it was ultimately helpful, but more so it was asked of us. And I really wanted to make sure if the experts involved thought it was necessary for them to review, they had that. Because I did think it was important that they really have access to any of the information that they felt like they needed to participate in this.
Yeah, and I would just add to that, I agree with that completely. And I think in this particular case, we needed the scientists to sort of reflect on a very specific transfer theory that the state had put forward. And what we were trying to do is say, what is the feasibility of this? Does this make, and so because the courts had really made the different possibilities that Cody Klepper had contributed this DNA, or the person that he had met earlier that evening, they made them equivalent. Like this is not a battle of an expert situation. So if it had been, I think we would have been far more protective of like trying to not generate any kind of bias. But this was not a close call in terms of the science. And I say that and invite Angela to come in and like say, qualify that. But from our perspective, this was not a close call. And what we needed to say, this untested states theory that is in fact contrary to the trial testimony, the DNA now completely contradicts that. So they had to concoct a theory that had never been tested, in the courts. And we needed the viability of the state's theory to be addressed in some way. And so it was a very specific, we wanted them to have the context because that's what we needed them to address in this particular case.
Right. And as has been said, not everybody, I mean, we cast a wide net. I probably talked to between 25 and 30 different experts. Many of them were, colleagues whom I've worked with for decades. Some of them were people who were referred to me from colleagues who, they thought might be interested. And so some of them, just based on our relationship and, knowing one another for, 25 years, were willing to sign on. Others, if they were going to put their name to something, they wanted to know, they wanted to make sure we weren't hiding something, or we, the fact that they couldn't exclude him from being a potential contributor to that DNA on the piece of rubber glove, that some people really fixated on that. And they wanted to feel comfortable signing on to be able to, see what was presented the first time and make sure that the brief that we wrote now correctly, or in their opinion, was consistent with the data that, the totality of the data that existed. And so, really ran the gamut. As I said, some were just willing to sign on pretty much just based on our relationship, and others wanted to do a full review. And I think we all respected the fact that, they weren't just blindly signing. They wanted to, and this was all voluntary. It was their, none of them were paid to do this. It was their time, and, just sort of for the good of the order, for, the interest of justice, they were willing to participate, but they wanted to be fully informed. And I can say, if I hadn't been the one that was calling all of these people together, and if I had just been contacted, I probably would have, maybe because I'm also an attorney, but I would have wanted to see everything that there was to be able to feel confident that if I was putting my name to something, it wasn't going to blow back. Most of these people are their livelihoods are as independent experts. That's, and so they don't want to have this come back and impeach them in a future trial, that their name is on something that, they didn't have all of the facts, and now they have to sort of backpedal and explain how, why they signed on to something that they weren't told everything about. So
Okay, great. Well, we are at time, and I want to, of course, say thank you so much, Sarah Beth, Laura, and Angeli, for this presentation and giving us a lot to think about in terms of these cases and use of experts. And of course, for anybody who wants to reach out to Angeli, please feel free to contact me. We'll be happy to put you in touch with her. Just wanted to plug 2 upcoming webinars for next month, December. We are not taking the month off. As most on this call are probably aware, cases like the Adnan Syed case in Maryland and Shaken Baby case in Tennessee, and even a case here in Pennsylvania, have run into some issues where the victims are trying to insert into the post-conviction process. We'll be discussing that next month, with the National Victims' Rights Attorney, Guy DeAndrea, as well as Val Newman, who may still be on here, to talk about ways to engage victims, to be able to try to have as much success as possible on agreed upon relief. And then in January, we will have 2 experts on shaken baby syndrome and abusive head trauma, talking about these cases, not from the perspective of, is this an issue, but just how to spot these cases, whether you're in a CIU or in an innocence organization. Mark Freeman, who's a private attorney, and Sunny Eaton, who is the director of the CRU in Nashville, Tennessee, will be joining us to talk about kind of 30,000 foot view about how to identify cases, how to kind of choose cases and potentially investigate what kind of issues to be looking for. So just wanted to give you guys a heads up on that. And once again, thank you so much, Laura and Sarah Beth and Angeli, and the unsung hero, John, who's also been kind of helpful with all this. And please let us know how we can be helpful in the future. Thanks, everybody.
thank you.